Is Monday, September 25th. It is time to conduct our Community Oversight Board meeting. I will read the appeal statement.
We do not have a quorum, but we can go ahead on stuff we don't need to vote on.
Our appeal statement. Pursuant to the provisions of 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under a common law writ. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met. That was a mouthful. All right. I'll go ahead and read the public comment section if you. So pursuant to TC 8-44-1, a period of public comment is reserved to provide the public with the opportunity to comment on matters that are germane to the items on the agenda. Each speaker is allowed up to 2 minutes to speak. Speakers may register in advance by signing up on the public comment sheet located at the entrance to the meeting room. All right. Mr. Secretary, do we have a quorum?
We do have a quorum.
All right. That is great. We will now review the minutes and move for approval.
Move approve as contributed.
I have one comment. So on the minutes on the on the third page, it says board member moved. Here, is that supposed to be?
No, that should have someone. Move approval with the secretary authorized to insert the name after review of the video.
All right. Is there a second?
Second.
All right. We have a second. All in favor?
Aye.
All right. We have approved minutes subject to that one revision.
What was the reason?
So it is on the third page at the top where it says board member moved.
First line.
We need a, yep. We need a name there.
I think it was.
I thought it was Brown, but we'll go back and put that in there. Okay.
Okay, thank you.
You're welcome. Thank you. So it's now time for our chair remarks. Here we are at our second to last Community Oversight Board meeting before we are reconstituted to the Community Review Board. I have not been looking forward to this day, right? As we get closer to the October meeting. But I do want to say to the staff, to all the people within the community, thank you. Thank you for the hard work over these past 4, almost 5 years to ensure that people had a voice in this community regarding police misconduct, police oversight. Thank you for the research that we've been given as Nashville residents and citizens so we'll know what's happening within our communities. Thank you for your leadership, Director Fitchard, A.D. Kiley, and everyone, all of the staff that played a part in ensuring that the people could feel safe, that they could feel seen, that they could feel heard. And thank you to my fellow board members who have put so much time and energy in lending your expertise, that expert police brain and knowledge that you've given us over these last few years. It really has, not only is your work respected, and even if you don't hear it often, your work is respected. Your voice does matter, and we appreciate your service. I could go on and on, but I'm not, Tora. I'm going to stop. And because I do think we have to ensure that the work that has been done, it may not have been perfect, but we were given an assignment, and the assignment was understood. And I just want to say on behalf of this spot, the chair's position, thank you for everything that you've done. I also want to say congratulations to our 10th mayor. As of this morning, Mayor Freddie O'Connell is Nashville's 10th mayor. The Community Oversight Board, which will be reconstituted October 27th to the Community Review Board, is eagerly looking forward to working with this new mayoral administration as we move toward a seamless and thoughtful transition to the Community Review Board. We are eager to work alongside this new administration. And just to give an update to our community, to our the people that have vigorously supported the Community Oversight Board, we have been working diligently with Metro Legal, with Human Resources, with hopefully soon to be the Finance Department regarding the reconstitution of the Community Oversight Board into the Community Review Board. There has been a lot of movement. There has been a lot of discussions and meetings, and those have and will continue. We are eagerly looking forward to ensuring that this new CRB, as of October 27th, will reflect and continue to provide the same level or even higher level of service to our Nashville and Davidson County citizens. And so what we will promise to do is keep the community updated, keep our supporters updated, keep the people who are intricately involved with oversight and with transparent policing abreast on what is happening with the COB. That concludes my remarks. We will now have our executive director's report.
All right. Thank you. I could say so much, but I'll wait and just go straight into the executive report. There's not a whole lot to add. This month, we just worked really hard on meeting with Metro Legal, Metro HR to talk about what they have told us, which is a layoff plan that has to happen. We met with HR today. We've also met with Metro Legal as we reconstitute into, reconstitute into a new department. It falls under Civil Service Rule 311, 3.11, which is similar to a reorganization. And what that means is our staff, 14 members, myself included, mine is slightly different, but the 13 members of our staff will have to go through a layoff plan. And so I am required by the Civil Service Rules to have that ready for Metro HR on Wednesday at the latest. It has to be done 30 days prior to the reconstitution plan. And so I will provide that, and then we'll see what next steps look like. But they did meet with us today for a few hours to answer any questions that the staff had. So I just wanted to put that out there. Mayor John Cooper reappointed Mark Wynn, our member Wynn, for a staggered 1 to 3 year term for the new reconstituted Community Review Board. The current COB members will continue to serve out their terms until October the 26th. And then the new Community Review Board members will meet, hopefully, we're hoping to meet on Friday, October the 27th, to confirm the appointment, possibly of an executive director, and nominate officers. The position for the executive director has been posted, and I'll apply, and we'll see what happens with that. But that, hopefully, that process will get through this administration. I know there's a lot of changes happening, but we know that we have to meet, regardless of whether the ED is appointed or confirmed on the 27th. The board has to meet on Friday, the 27th, in order to stop the 120-day count. So just wanted to put that out there, that you will be getting notification of that. And I would like you guys to clear your schedule as quickly as possible for that Friday morning so that we can have a CRB. I attended what we usually have is a department head meeting, but it actually was a kind of, all department heads received the going away a reception invitation for Mayor John Cooper. And so a lot of people were there to listen to some of his successes and things that he did for the city, and to just spend a little time with the mayor at that point. And it was nice. It was a lot of department heads were there. So that was last Wednesday, September the 20th. We have received 3 complaints since our last board meeting. We received a few more within the last few days, but since Dave was on vacation, we didn't get to add those in. So I think it's more than 3. It's probably like 6. But those will be added in. And then a total of 30 complaint and contact calls for service. And out of that, we chose those 3. Dave will look back over, since he was gone for a week, to see if any of those will end up being complaints. We are working on a process on how to gather the complaints that we have that we won't be able to complete, to get those over to the Office of Professional Accountability. I think it's important that we set up a time to meet with the chief and his staff to understand what that process will look like, because we do have outstanding complaints, and they continue to come in, and they'll continue to come in up until October the 26th, I'm sure. They haven't stopped coming in, and so we want to make certain that we have a really good, solid plan to be able to take those, so that citizens who are using our service still know that in this interim time that their needs will be met. So that's hopefully will happen soon. And then we've just been really busy with trying to make certain that we educate the community on this transition. A lot of people, we met with IMF, we talked about the use of force report, but then we went into what does this look like? I mean, there's still a lot of community concern about the COB going away and turning into a CRB. People don't really understand the differences in what the services that we'll be able to provide, as well as, of course, there's still a lot of discontent with the fact that the state has come in and changed something that they voted for. And so trying to educate them on what the differences are, what will happen, but also still our involvement is still important to them. And so telling them about the fact that we are able to review the complaints that come in once they come back from, once OPA has completed them, then we will request them and make certain that, that it's done thoroughly and completely. And so, that's been a big challenge. We continue to have a lot of, I appreciate our community engagement arm, because they have reached out, and people have reached out to them, and they've been very, very busy trying to educate the community on what's next. And so have been invited to a lot of community events, and some of them are listed here. Recently, the Coming to Casey Cookout, that Stratford High School NSST department, which is like the community justice arm of, Stratford High School. They worked in collaboration with the Martha O'Brien Center. And that was a really big turnout. A lot of young people were there from the community as well as Stratford High School. There's a lunch and learn with Tennessee State University tomorrow. There's an annual Stand Against Racism rally. There's, of course, I don't know if you all know, but the mayor has decided to have his inaugural celebration for not only himself, but also the council at the public square on Saturday. It starts at 10 a.m. and has asked all departments to participate by bringing their materials, their swag material, their marketing information, their tents, to have it where when you come there, you get to know what all the departments offer. And so I think that's a really brilliant idea. And they coined it the Nashville Coming Together event. And so I think that's going to be really great. Those are some of the things. We continue to have trainings. I just recently took a training, participated in a training with Cornell University's leadership webinar series, Better Decision Making, Solving Problems. Leading with Conscious Inclusion was offered by the Metro Human Resources Department. And then, of course, they still do the NACO. Our investigators and just all the staff can join in on the Investigators Monthly Forum. I will say that myself and some of the others have participated in a lot of events this month. I was a guest speaker at the Black Tennessee Voices Storytellers, which was hosted by the Tennesseans. Black Tennessee Voices, David Plazas was the moderator there. I'm a panelist for Air Equity Initiative Symposium, Pathways to Peace. That's going to be on October the 12th. And so I have that information to share. It's going to be a lot of different departments from Metro that'll be involved in that, as well as some from Vanderbilt as well. And then, of course, the NACO conference is still coming up. Our research team has been working really hard on the Sexual Misconduct Policy Advisory Report. And we'll ask the lead researcher, Mr. Crowell Williamson, to talk a little bit about that. And then an informational research report on Fuses technology, which you all received. And so Dylan DePriest will talk a little bit about that today. And so that's pretty much it. We still get calls, like I said earlier, since our last board meeting. They continue to call and offer their support, voicing their support for my leadership, as well as all of the staff here. And it's just been a tremendous amount of, it's just been a lot of work to try to make certain that we are meeting the needs of the community. We have a very short period of time to get things transitioned, and also balancing the possibility of a layoff and what happens next, because there's a lot of unanswered questions that we still have to go through that. Of course, we have a new mayor. He's got a big transition happening. And so we just have a lot of things to do in a very short period of time. And I think it's going to take all of us working collectively to get the answers so that people have some relief on knowing what the next steps are. We turned in what Metro HR asked us to do, which was to turn in new job descriptions, functional job descriptions that could transfer over to the CRB. So we had that work completed for them, that package. And today they said that was great. Everything seemed to look good for them. And so the next step is just seeing if the next step in this process to make certain that the director of finance, or whoever the interim director is, or deputy director, will give us the positions that we have asked for. So that concludes my report. If you have any questions, I'll take them now.
All right. I just want to say thank you for this thorough report. I wanted to make sure that everyone is aware the level of engagement, thoroughness, preparation that is going into these meetings with Metro Human Resources, with Metro Legal, and hopefully we'll be able to meet with the finance director soon, once that interim is named, or, whatever that next step is. Being thoroughly prepared is step number one, and I think we have taken care, and taken a really good step in the right direction. Because when we met with HR about 2 weeks ago now, I would say, all of the information that they were requesting was right in front of them, right? When it pertains to job descriptions, when it pertains to job duties, and what we see and how we see the Community Oversight Board being reconstituted, and with the staff that we have now. Right? And so not knowing and having the ability to shape the CRB into what we know it can be, was well received by human resources, at least from a standpoint where we gave them the information that they requested, and that information was very sufficient. It was sufficient when we were talking about positions. It was sufficient in job duties. It was sufficient in functional duties. And so we want to make sure that everyone understands that the COB is doing what we're supposed to be doing. Okay? And even with Metro Legal, we did have an opportunity to meet with the law director last Wednesday. And that conversation went into executive session, but I will say it was a good conversation, and it provided additional clarity for executive committee members to, as we advocate, as we ensure that we are making decisions that are best on behalf of the COB staff. To lift up, the complaints that we will not have an opportunity to hear. Because what I heard from Director Fisher was there are complaints that we will not be able to review as a board. And that is very disheartening to me, right? We knew that this day was going to come, but where will people go? Where will these cases be heard in an objective way? And it's not fair that people will have their cases lingering or left by the wayside because of a law that the Tennessee General Assembly enacted. And what we want, at least from my perspective, and I can only speak for myself, is justice for the people whose cases won't be heard, whose complaints won't be heard. And for people who care about oversight in our community, what must we do? What must we do when we are talking about people who have issues of misconduct and now they will no longer be heard by the COB? There has to be a remedy, because what we know is even though the COB will cease to exist and we will be the Community Review Board after October 27th, what must be done? Now, I just want to leave that question out there because I do believe that we live in a time and a community where even though we may not be able to get justice one way, there may be a possibility for us to get justice somehow. We will have the CRB meeting, that first meeting on October 27th. So I need all my board members who will be a part of the new community to mark your calendars. Member Brown, I know you marked out the whole day, didn't you? Thank you. I appreciate that. And so those are the same expectations for everybody else who will be on the Community Review Board as we are working out a time to meet that morning, preferably.
Remember, there's only 7, so we need all of y'all to show up.
We need all 7 present and accounted for.
Location.
Those are the details that we have to work out, just because it really depends on what the layoff actually looks like. Who will be putting out that notice? Metro Legal has extended their hand to put the notice out for us, to post the agenda and all of these things. So those are the details that we're kind of waiting to etch out. I do want to mention I was in attendance for the Tennessee Black Voices, where Director Fisher was what do you call it, a panelist, a storyteller, and she did great. And I would ask that all the board members, community members, go back and look at the Tennessee Voices, Black storytellers. so you can hear the powerful story that the executive director told on stage at the National Museum of African American Music. That was a very proud moment for us COB board members, so make sure you go back and check that out.
Where can we find that?
Probably on the Tennesseans website, I would think. So David Plaza's, curated it, and him and LeBron Hill. So I'm sure anywhere you find Tennessean.com, you can find that. Mm-hmm. Any additional comments regarding the director's report?
Yeah, really quickly, I'm just interested in knowing how have those conversations been with those complainants who know that their cases won't be heard. How have those conversations been?
Yeah, we haven't had that conversation. We're going to be in talks with how we were going to do that. I think it should be very personal and not just a letter in the mail. Also, I would have liked to be able to tell them that this is what the process looks like. Like, we're going to send this over to OPA and this is what they've said and all that, but we haven't had that conversation. So the first thing is to try to reach out to, we were supposed to meet with Chief Drake. We asked almost a month ago for a meeting with him, and he was supposed to set that up. I haven't reached back out. I can reach back out and see if we can do that before I make contact with all of the complainants, because I don't want to just say, hey, call OPA. I mean, because that's not what they wanted to do in the first place. They wanted to deal with us. But my hope is to be able to say, this is what your process is going to look like. Once they finish, it comes back, and so on, so that they know that we still have a hand in it. But until I talk to them, I don't really have that second part of it. And I wanted to just be really careful and considerate in how we are going to message that. So we're still working on that.
Thank you.
Just one question. We've still got a little time left. Is there any of the present complaints that could be presented to a special call meeting before we end? Obviously, it couldn't be many, but are there just one or two that seem to cry for some sort of a decision?
Well, yeah, I think I'm going to let Dave answer that, but we have, identified the kinds that were, I think, urgent needs that we needed to do, and that's what you're seeing. And really, now that, we still have Daniel and, Sarah's been, that Frank, what is it, the Brazil Clark? Brazil Clark has been, I always want to say, but anyway, Brazil Clark has been working with us. So I think that's something that, Dave, you want to answer that?
Yeah, I mean, it's kind of the same as it ever was. We're going to try to get as many done as we can, but, we're still missing a lot of records. We're not getting any records. So, yeah, I mean, I'm hoping to get a few more done, but it's,
I would love to have
kind of up
special call
behind the eight ball.
We could get some, between now and our next executive committee meeting, and then have some on the 25th. I mean, that would be my goal here, and we're going to work on that. Just to identify if there's a few that we can get in, whether it's 3 and then another 3, that would be great. But right now, I think we have a lot of, I'm not going to say that they're low level or anything like that, but some that don't rise to it. And the problem is the record issue now, because after July 1st, we haven't been able to get the records to be able to do it, so, yeah. But yes, we're going to try.
I think, so kind of to piggyback off of Member Whittle and Member Brown's question regarding complaints that won't be heard legally, what are the options if we're talking about, the law that was written to, abolish the Community Oversight Board? And so what happens to those complaints legally? Are they still able to be heard? I mean, I know they could go and file a complaint with OPA, but as it pertains to filing that complaint with the Community Oversight, right? Do they go away? I mean, are rights infringed upon? What are we talking about?
I think I'll let Metro Legal speak for themselves a little bit, but I think under their theory, when the Community Oversight Board terminates on the 26th, there won't be any action that we can take on that at that time. Obviously, under the theory that the Community Oversight Board is being transitioned into the Community Review Board, I think there's a little bit of wiggle room, but I think the safe bet would be prior to October 27th, all of the pending complaints should either be closed out by this office or referred over to OPA. And by closed out, I think that this is a civil process. This is a scenario where maybe a complainant, maybe more than one, maybe witnesses have told us something has happened. An opportunity, I think, in most of these cases has been to allow for people to respond and give their side of it. If they elect not to, this is a civil proceeding. This is an administrative proceeding. And I think the preponderance of the evidence would say that the testimony stands. It's corroborated by the fact that we have an incident report that says something did happen, a police officer did arrive, and we have undisputed evidence that it was a violation. You know, that might be a finding or a conclusion in favor of the violation. Obviously, OPA would do their own investigation and they'll make a finding one way or the other. And maybe the police officers will speak to them, but not to us. But yeah, I think the referral should happen prior to October 27th, I think, to make sure that OPA does accredit our referral over to them and our access to those records, because post October 26th, we may not be able to access the complaints that those COB received.
Okay. So we may need to have a meeting regarding what that looks like, right? And create a schedule and a plan to refer those complaints over. Any kind of other legal analysis, Attorney Yoon, you could provide regarding, that the reconstitution and transitioning over and what that actually means for complainants, like, realistically, right? Like, what does this mean for the person who filed a complaint with the COB and it will not be heard?
Because I think the CRB is authorized to receive complaints that occurred after January of 2023. So what the COB could do is, as their last action, send it in the mail to the CRB on the 26th. And then once the CRB receives the COB's referrals, there's a process that will take place from there. So obviously within 3 days of reception, and that might be delayed a little bit because we don't know what staff the CRB is going to have.
Right.
But once the CRB receives it, has a process in place, the CRB can then make those referrals over to OPA using whatever SOPs that they have. But I don't think the COB necessarily has to just give them to OPA directly. They could also give them to the new CRB that's constituted.
Okay, thank you. Member Goddard.
Legal Advisor Yoon, one thought occurs to me is, that's a question, not for you to answer right now unless you want to, but look at between now and next meeting, is whether it makes sense both to have the additional staff authority of this board and in procedure to have a list of all of the complaints that have not been able to be finalized, and if possible, a little half paragraph of what they amount to, have those presented by staff to the board, and the board officially authorize sending them to Metro OPA or the MNP OPA or the chief, whichever it is. And then let one of the first actions then of the CRB 4 days later, 5 days later, whatever it is, can be to adopt that and take the same action. That both gets it there formally, I think, and I would argue we need to talk to the chief or Assistant Chief Hagar. That should start their 45-day clock. If we send a complaint over, they've got a process that gives them 45 days to investigate that. Now,
that's why I think it's important that we have a conversation with them, because
Yes.
when Director Moranti was at the last CPA meeting, she alluded to them hiring more staff to be able to, I guess, work on these cases or something of that nature. I got that secondhand. But anyway, my concern is they may have created policy that we're not aware of because of this new thing that gives them more than 45 days. I just want to be clear that we're all on the same, we're tracking the same, that if they have now changed it from their regular 45 days, since they're going to have an influx of new complaints, to now, it's 60 days. Whatever it is, we just need to know. And I think it's important that we have that meeting. So the expectation is that they're not going to, like, if we're expecting them in 45 days and they're saying, no, it's going to, We just need to know if they've made new policy change around this new action, this new legal action where the CRB is going to send them any complaints. Because we're kind of like this new repository for complaints. We just need to know what their process is. I mean, we know the old one, but I don't know if they've changed that.
I agree completely.
Yeah.
And that adds something to my thought is if the COB makes the direct referral over to OPA, there's no guidelines on who follows up. The CRB does have that type of guidelines. So in my mind, without looking further into it, I am inclined to say that it might make more sense for the COB to make referrals to the next CRB. That way the CRB can track these OPA complaints in a more formal way. Because there has been anecdotal evidence, I think, or suggestions made that the OPA, when they receive them from people in the community, if they don't get a response back by the complainant via voicemail, they just drop them and they don't do further investigation, or they will simply look at body-worn camera without speaking to the police officers and then close a complaint without doing more of a investigation. That we would consider an investigation.
Okay.
So it sounds like to me that we need to work together in creating policy on how the two agencies will work together.
Yeah, I totally agree. And I think the challenge has been the COB being very prepared and, eager to have these conversations, but that same preparedness or maybe eagerness is not being reciprocated, right, from the Metropolitan Police Department. And so I would ask that we do get that follow-up. At least we can follow up on our side because we have already made that engagement and we have not received a response from Chief Drake regarding the meeting that we requested over a month ago. Or is it a little over a month? Okay. All right. Any additional comments?
I'd just like to say that the COB, their staff, has done a great job in representing the residents of Davidson County. And it would be easy to roll the staff over than it is to lay off people and try to refinish a new department. A great leader would see that this is the best thing to do, and I'm looking forward for it to happen.
Thank you, Member Holloway. I think a lot of us share that same sentiment. Making the transition as seamless and as possible, causing less anxiety, right? It's already a very contentious moment in the life of the COB, yet another time. But I do think we can all agree that the smoother the transition is, the better off not only the staff will be, but the Nashville community. Okay. Our time for public comment. Do we have anyone signed up for public comment? No one? No one wants to say anything? Not even how you doing? There you go. State your name, please.
My name is Michelle Flynn. I have followed the Community Oversight Board since it's the early efforts in our community to get one. And it's very disturbing that, to your comment, Mr. Holloway, respectfully, that this administration that is leaving had not seen the wisdom to go ahead and have the staff who's done this amazing job be transitioned in. I do not understand why Metro Legal has not taken a much more assertive stance in relationship to this. I feel like you all have done an incredible job to be responsive to the limits that have been placed on the COB in this transition, but it's very disheartening that our current legal department has not seen the wisdom to push back in all the little crevices that are possible to actually honor the work that the COB has done. Yeah, it is emotional for many people in this community. Yeah, and to go ahead and just transition a staff. Part of it is like, there's so many people out there who have been traumatized in this community, not only from the actions of the state to not protect people, but also within our own city, people who have been injured. And, you just expect a lot more from your local government to stand up, and by protecting the COP as it's constituted, the community feels protected. So it's really a shame. And so I just want to go on the record to say there are many people who are quite disturbed in the city that there's not been a more assertive stand. And I'm really calling on our new mayor, our new council people to not put this new staff that's going to be there, hopefully it'll be the same staff, but the new director particularly, through any more of these random changes that are being asked for. We need some smoothness, we need transparency, we need accountability. We have asked for that for years now. We have voted for that, and I would say we're pretty darn tired of this constant undermining of the work that has been undertaken by people in the community to ask that our police department work with the community to make all of us feel like we are secure, we are safe, and if you're doing a darn good job, you do not have any problem with being transparent and accountable. And I feel like the COB has done that, and I feel like under this new administration that's coming in, there should not be a question of pitting the Community Oversight Board and the police department, right? There should be this bigger umbrella that has to do with all of the folks in the world of mental health, in the world of policing, in the world of oversight, in the world of juvenile justice, in the world of district attorneys, in the world of public defenders. This city is at a wonderful point of saying we should have an umbrella of folks who are really looking to position the city in a very forward-looking way about, and violence interrupters. I mean, this is an umbrella under which we all, as a community, exist. And so rather than these silos and these weird kind of, I don't know, we promote some and we don't promote others. No, this should be the way this city operates going forward, because I think all of us will feel then, we can be, not that we're relaxed because we always have to be ever vigilant, but that we feel like folks are really working together to pull forward this community, into this next period of time, because we know there may be more coming down from the state, right? We're concerned about over-policing of youth. We're concerned about people not being released from prison and things being extended. We're concerned about juveniles being, tried as adults. There are many folks who are being affected in our community because of actions. And I'm not saying all of what the state legislature is doing is wrong. I'm just saying we are all partners in making our communities safer for all. And we know the burden tends to fall on Black and brown-bodied people when we're talking about all of this stuff. And it's just wrong. We're tired. We just want things to work and work well. There should be no reason at this moment that doesn't happen. Thank you for hearing me out.
All right. Yes, Christopher.
Okay. Hi. First of all, my name is Kelly Chen. Do you need my address? Anything else? Okay. I'm used to speaking at council where they ask you for all those things. First, I just want to say a huge thank you to the members of the Community Oversight Board and the staff. I can't imagine how it is to work under what feels like constant attack or being blocked at every turn with the incredibly important work you all do. And I also just find it horrifying that the one metro department that, from my understanding, at least in recent memory, is the only one that was created by the people for the people, is now having its entire staff laid off. And from my understanding, the majority of the staff are Black women. And we're hearing that there's going to be people rehired, but from my understanding, which is obviously very limited, I am not part of these conversations, there aren't any guarantees. And I think every job that the people at the Community Oversight Board do is incredibly important, and we need all those jobs. And I guess I just have concerns around if there's already been, the budget has already happened, so the money has already been allocated. So it feels like all these extra hoops are being set up specifically for the members of the Metro Nashville Community Oversight Office. And in my humble opinion, there are ways that a lot of this could be avoided. I'm also incredibly concerned about people who have filed complaints. As we know, most people who face mistreatment or police brutality have already faced a lot of other traumas, marginalization in their life, and it just feels like this is yet another thing that says you don't matter. And obviously that's not coming from you all. That's just how this is playing out. And I think a lot of people who have supported and have faith in the Community Oversight Board find this horrifying because it's just yet another, it doesn't matter what happened to you because we have set up this procedure and Metro Legal has said this and the finance department has to weigh in and all these transitions have to happen. But while that happens, these people have been traumatized. Further people will continue to be traumatized. And I don't think that people who have been paying attention have a whole lot of faith that this is going to be a smooth or seamless transition. And so I just encourage anyone who is listening, watching, we need to hold Metro Legal accountable. We need to hold Human Resources accountable. We need to hold the Finance Department accountable. We need to hold our new mayor, Freddie O'Connell, who I voted for, accountable as well, because there is nothing else in this city like the Community Oversight Board. 137,000, I believe, people voted for it. And so people not only who are victims of police brutality in this city or misconduct are being silenced, but also 137,000 people are being silenced. And so I just think it's really important we keep that in mind, and we also keep in mind exactly who needs to be held accountable, who needs to be watched, who needs to be questioned, who needs to be pushed. And I just hope that a month and a few days from now that we have a community review board with Director Fitchard at the head of it and the same staff who are here now. And I personally will be pushing for that, and I hope everyone else does as well.
All right, thank you for those comments. Anyone else? All right. That concludes our public comment section. Period, I'm sorry. Now we will go on to proposed resolution reports.
Proposed resolution report CC 2022. Is it 19 or 040? 045 is up there. Okay. The allegations of misconduct against Officer Juan is honesty and truthfulness, profanity, grounds for arrest by officer without a warrant, Number 4, adherence to rules by way of procedures for enforcement and contacts, stopping the violator. And number 5, use of force de-escalation. Against Officer 2 is honesty and truthfulness, profanity, grounds for arrest by officer without a warrant. Number 4, adherence to rules by way of procedures for enforcement and contacts, stopping the violator, and use of force de-escalation. The summary of the complaint allegation is on August 14, 2019, the complainant was driving with her 8-year-old son in a friend's vehicle. The complainant was followed by an unmarked MMPD vehicle for approximately 15 minutes. Eventually, Officer 1 and Officer 2 attempted to initiate a traffic stop due to the complainant's expired tags. The complainant failed to pull over the first 2 attempts by officers. Officers initiated a 3rd attempt to stop the complainant's vehicle, to which she eventually complied. Officer 1 and 2 exited the unmarked patrol car with guns drawn and ordered the complainant out of the car and informed her that she was under arrest. The complainant alleges that officers used profanity while ordering her to exit the vehicle and that she did not realize that the car following her was an unmarked police car ordering her to stop. She alleges that Officer 1 and 2 falsely arrested her. The policy violations here would be, and let me read them. MMPD Manual 5.40.020, grounds for arrest by officers without a warrant. Policy 4.20.040J, profanity. Policy 18.10.030E, procedures for enforcement, contacts and stopping the violator. Policy 11.10.030M, use of force, de-escalation, and policy 4.20.040A, adherence to policy and rules. The facts of the case is on August 14th at approximately 9 p.m., the complainant was driving with her son in a borrowed vehicle. The tags were expired. Officer 1 and 2 were in an unmarked police car, and they began following her upon noticing the vehicle had expired tags. In her interview with MNCO, the complainant stated that she was aware of the unmarked car following her, but expressed fear and apprehension because she did not know it was an unmarked police car. Interviews with Officer 1 and 2, as well as the Officer 1's preliminary hearing testimony, show that Officer 1 and 2 had deployed their emergency lights and sirens briefly to attempt to pull the complainant over, but she failed to stop, or the complainant failed to stop. They continued to follow the complainant. Interviews with Officer 1 and 2, as well as Officer 1's preliminary hearing testimony, shows that Officer 1 and 2 deployed their emergency lights and sirens a second time. Complainant failed to stop. Officers observed the complainant turn and almost hit a pedestrian. Officers then called an aviation to follow the complainant. Officers deployed their emergency lights and sirens a 3rd time. The complainant eventually stopped at a red light. According to interviews of the complainant, Officer 1 and 2, both officers exited the unmarked vehicle with their guns drawn, ordering the complainant to show her hands and to get on the ground. When the complainant exited the vehicle, she told officers that she did not see them. The complainant was hysterically crying when she exited the vehicle. Officers arrested the complainant for felony evading arrest under Tennessee Code Annotated 39-16-603B. Officers allowed the complainant to call a family member to pick up her minor son when she was under arrest. So the discussion and analysis of this case is honesty and truthfulness. That allegation was unfounded. The testimony offered by Officer 1 at the preliminary hearing for the complainant's case, there is no body-worn camera footage or other visual recordings of the incident to determine whether or not the officers, were not telling the truth as to the events leading up to the complainant's arrest. But it was corroborated by their testimony at the preliminary hearing. Grounds for arrest by officers without a warrant. Officer 1 and 2 initially attempted to pull over the complainant for driving a vehicle with expired tags. That is considered a felony, and they it was what they considered a felony stop. And she failed to pull over. Officers had probable cause to arrest the complainant without a warrant. There was some inconsistencies because of no body-worn camera footage available in this case. The CAD recordings of the incident show Officer 1 speaking in a calm demeanor with no use of any profane or indecent language. And due to those inconsistencies among the complainant's allegations, with the officer interviews and testimony, there wasn't enough evidence to uphold the allegation of profanity against either officer. D, which is the adherence to rules by way of procedures for enforcement or using an unmarked police vehicle. The policy states that if a driver is unwilling to stop for an unmarked vehicle, the officer will not force a stop, but will give the driver reasonable time to find a comfortable or safe place to stop. The complainant failed to stop for Officer 1 and 2, and also in her interview, she said she felt uncomfortable with stopping for the unmarked vehicle. This fear and apprehension is a legitimate fear that is reflected within the policy. While Officer 1 did call in aviation support to respond and help track the complainant's vehicle, officers never called for a marked patrol car for assistance, which is what the policy allows. Calling for a marked patrol car is required under MMPD policy, but that was ignored by Officer 1 and 2. Calling for a marked patrol car would have removed the veil of ambiguity and apprehension. Complainant expressed that she expressed and could have given her the opportunity to comply with the officer's commands. And for those reasons, that violation is sustained. The use of force for de-escalation, it says that officers, let me go back. Officer 1 described this as a felony takedown through the display of a firearm. This use of force was reasonable within the parameters of the policy due to the officers observing a complainant committing a felony offense. The complainant appeared resistant to stopping and an apparent flight risk, presenting a potential threat to injury to citizens as officers observed her nearly strike a pedestrian. However, officers could have avoided this use of force by complying with their policy 18.10030 and calling for a marked patrol vehicle to initiate the stop. Because officers only initiated emergency lights and sirens temporarily on 3 separate occasions, it is unclear whether an official presence was established. Officers never deployed their emergency lights and sirens for an extended period of time, nor did they attempt to announce over a speaker or megaphone for the complainant to pull over. Not establishing a clear official police presence denied the complainant the opportunity to comply with a clear and unambiguous command to stop. It created legitimate fear and apprehension and escalated the situation where officers immediately displayed firearms upon approaching the complainant's vehicle. Failure by Officer 1 and 2 to call for a marked patrol car or give verbal commands over a megaphone reflects a failure to de-escalate the situation within the requirements of the policy 11.10.030. And so this led to firearms being displayed unnecessarily at the complainant and her child. And while interviews do show that upon discovering the child, officers holstered their weapons, but the initial display could have been avoided. So the conclusion in this case is by the preponderance of evidence reviewed, the executive director concludes the allegation of honesty and truthfulness against Officer 1 and 2 is unfounded. By the preponderance of evidence reviewed by executive director concludes the allegation of profanity against Officers 1 and 2 is unfounded. By the preponderance of the evidence reviewed, the executive director concludes the allegation of adherence to rules by way of procedures for enforcement contacts using an unmarked police vehicle against Officer 1 and 2 is sustained. By preponderance of evidence reviewed, the executive director concludes the allegation of grounds for arrest by officers without a warrant against Officer 1 and 2 is unfounded. By the preponderance of evidence reviewed, the executive director concludes the allegation of use of force de-escalation against Officer 1 and 2 is sustained. The recommended action, Officer 1 has sustained violations for use of force, de-escalation, and procedures for enforcement contacts using an unmarked police vehicle. A review of his personnel file revealed no relevant disciplinary history within the retention period. The executive director recommends that Officer 1 undergo formal counseling for use of force de-escalation as a Category F offense. As for the sustained violation for adherence to rules by way of procedures for enforcement contacts using an unmarked police vehicle, the executive director recommends Officer 1 receive a 1-day suspension as Category D offense. Officer 2 has sustained violations for use of force, de-escalation, and procedures for enforcement contacts using an unmarked police vehicle. A review of his personnel file revealed no relevant disciplinary history within the retention period. The executive director recommends that Officer 2 undergo formal counseling for the use of force, de-escalation as a Category F offense. And as for the sustained violation for enforcement contacts and the use of an unmarked police vehicle, my recommendation is that Officer 2 receive a 1-day suspension, Category D offense. That concludes CC 2022-045. I'll take questions.
I had one question. Between the two officers, was one of them in charge, or were they both equally responsible? Very often, one of them is senior to the other, and so we're obviously recommending the same thing for both officers, but and the other question, I guess, is did they consult with a supervisor or anything?
Yes. So the second one's the easier one. They were, and that's some of the corroboration was that Officer 1, so Officer 1 is driving, Officer 2 is in the passenger seat. I'm not sure, honestly, it does not appear to have been an FTO situation, so I'm not sure why the two of them were in there. But they were, they can be heard both talking to dispatch. Officer 1, while he didn't request a marked car, requested aviation. And so similar to with a high-speed pursuit, they were not engaging in a pursuit, and they're very clear about that, but they were providing information to dispatch along the way. And so we kind of have that in the moment corroboration. But
Yeah, if one was an FTO, I would think he would be the most responsible for it. But if they're equal, then they're equal.
yeah. That's kind of how it appeared. Yeah.
Is that was your take on it?
Yeah, I was going to say, from listening to everything and reviewing it, it doesn't appear that there was any, change in rank, or one's an FTO and one isn't. They were both, communicating on everything, so.
Member Wynn.
So I had a couple of questions. So the vehicle was unmarked, but did it have emergency equipment on it?
Yes.
Lights and sirens. And they activated their equipment when they made the stop?
Ish. So, and that's one of the difficulties with this is that it's not super clear. We don't have body cam or dash cam. Dash cam will just tell you when the lights and sirens go on. Officer 1 in his interviews makes it clear that it was not a sustained activation. So the lights go on, they kept them on for a period of time. It's not super clear, and they gave some blasts of the siren, so not the long sustained siren, but some, what I understood to be kind of honks from that speaker on the front. And so that's kind of where the concern about the ambiguity came from, was that you do have emergency equipment, but you have an unmarked car, and it was not clear that those things were being activated continuously. So putting yourself in the position of the driver, I think there is some ambiguity to that. Am I being told to get out of the way? Am I being told to pull over? What is the order? And I think that is one of the real shortcomings of this interaction. And it's unfortunate that we don't have the body cam, but it also didn't seem, there wasn't a lot of evidence that the officers were being inconsistent or untruthful. And so we kind of have to credit their statements there that they did activate them, but it did also appear that they were activated only briefly and kind of intermittently.
So they turned the lights off and on?
Yes, but again, why I wouldn't necessarily hold that against the officers is that their explanation was they're trying to signal her, but they were also trying not to instigate a pursuit.
Okay.
And so we're kind of on a fine line there. but the preponderance of it seemed to support what they said, just because their account of it fit together more than the complainants did, frankly.
So I have another question. So is it clear the timeline from the moment that they asked for a check on the plate to the time that the car stopped?
Is what clear?
Well, how long did it take from the moment they ran the tag and realized it was expired to the time the car stopped? Did they notify dispatch when the car pulled over? In other words, was it 10 minutes? Was it 20 minutes? Was it 2 minutes?
It's 10 plus minutes, and I mean they are in communication with dispatch and then aviation the whole time, so they do alert pretty immediately, at least when they get on the radio with dispatch saying, we've got this car, the tags are bad, and then saying, I think there's 3 different lights where they're saying, this person keeps pulling off. So I'm not sure if that answers your question.
If we're saying one of the officers did notify a patrol unit, then if they notify patrol, how long would that have taken? We don't know the answer to that, do we?
We don't, yeah, and I think that's fair. I mean, they did notify aviation, but then it's just kind of back and forth with aviation. So I'm not sure why marked units were never requested, especially because the unmarked car is kind of saying we're hanging back, we're not going to pursue, we're not trying to initiate a chase.
Right. Well, could it be the reason that an unmarked car wasn't called that the car stopped?
It could be, but we weren't able to interview officers for this one, so.
I'm sorry. Yeah. Can you repeat that again?
We were not able to interview officers, so unfortunately there's some open questions like that. Same thing with, to get more specifics about what kind of signals were given. I think the answers that we have and the answers that are in the preliminary hearing are not the most clear. But the officers are in agreement that the driver was signaled, and I think one of the major facts too was that this was later in the day, and one of the officers remarks that he remembers it being dark or the sun going down because he remembers seeing the blue lights reflect off the buildings, and that's I'm not sure I'm answering your question.
No, I mean I can understand why we would fault them if they just didn't consider calling a patrol unit. But if the car stopped and they had activated their emergency equipment, there'd be no need for a patrol unit.
That is correct. Yeah.
Okay.
That is true. And so it's one of those where it's just it's not clear why it was never done, and it doesn't seem like there was a very good reason not to do it.
Right.
Especially because we're calling in aviation over just an expired tag. It just seems weird. It's like, why would you call them?
Right.
I get it, to call them to follow the car, and that helps them avoid a high-speed chase, so that makes sense.
Yep.
But especially with how much acknowledgement there is saying, okay, we understand the driver might be afraid, there doesn't seem to be any reason that they didn't, especially because the pursuit comes all the way from Bordeaux, down Clarksville Highway, and then down into the neighborhood around Meharry. So, I mean, you're talking 10 plus minutes. Yeah.
They were to call, they needed to call an unmarked vehicle.
Yeah.
And they didn't. They called aviation instead.
All right.
So that's why the discipline is what it is, based on that policy.
I'm sorry, one other thing, not that it matters, what happened to the case in court? Because it starts off as a non-moving traffic violation, and then it turned into a felony evading.
And then it was indicted and ultimately dismissed at the request of the state. So for everyone watching at home, that's the request of the prosecution. They dismissed the case of their own volition. So I'm assuming they had some other evidentiary issues going on.
Thank you.
So the case was dismissed ultimately?
By the district attorney's office, yes.
By the DA's office?
After it was indicted, I believe the complainant said about 12 court dates that she had. So the court process drug on and on, but that's not uncommon.
All right. Member Wetzel.
I don't know if I still have a question. Is there anything, I was curious, it doesn't say anywhere that there was ever any speeding or anything on the part. And so is there does policy state that a marked vehicle needs to be called within a certain amount of time? No.
It doesn't give a time. It just says, it's just kind of a, you will do this. And I think going back to that time, one of the officers' rationales is that, at this time, everyone knew that we were driving these unmarked Malibus. Well, I knew that because I was a public defender, and I'm sure there are some other people that knew that. But there is kind of a disconnect there, and I think that was the concerning part, was why are we doing unmarked traffic stops? At that time, I think it was pretty normal, but it was part of proactive policing, but I'm getting off the topic.
I'm going to read the policy just so that you have some clarity on it. It's very short. It says, using a marked police vehicle, blue lights, flashing headlights, emergency flashes, horn, and if necessary, siren. And it goes on to talk about the spotlights or hazardous warning lights should not be used to signal violators to stop due to the possibility of temporary blindness of the violator and other motorists due to the glare created by these lights. Using an unmarked police vehicle. A, if a driver is unwilling to stop of an unmarked vehicle, the officer will not force a stop. The officer will give the driver reasonable time to find a comfortable or safe place to stop. If the officer feels the driver had this opportunity and the driver is not going to stop, the officer will call for a marked unit to help the stop. B, officers shall not attempt to make traffic stops in their personal vehicles. So.
Thank you for that.
Any additional comments?
So the policy says reasonable time. That's my concern. Did they give the motorist reasonable time before they call for a marked unit? That would be the question.
Well, they called for the helicopter, and then of course there's this allegation that she may have almost struck a pedestrian. So.
Well, that brings up a question I made a note of. So they charged her with almost hitting a pedestrian?
They did not. Yeah. They did not. They charged her. They only charged her with felony evading.
So they wrote in the report that she almost struck a pedestrian, but they didn't charge her with almost striking a pedestrian?
Correct. And there's not a huge amount of detail about what that means, almost struck. The officer, too, in his, he says that around that area, there are kind of always people kind of wandering around. I think, I took that to mean unhoused people or whatever, that there's always a lot of pedestrian traffic in that area. But again, there's not a lot of detail about almost hitting someone. And the complainant did emphatically disagree with that statement. To go back to your time thing, though, I brought up the CAD, and it's not super clear because Officer 1 dispatches and marks his arrival at the same time, 4 seconds apart. At the exact same time. So we can only go off of the 911, so I can only give you that it's 10 plus minutes.
Yeah, my concern is if they ran the plate, it took the dispatcher a while to run it to see if it was stolen. It's not, it was expired. And then they initiated their equipment to stop the car. If it's 5 minutes, if it's reasonable time, then she finally pulled over. I'm having a hard time faulting them for not calling a marked unit. Now, I understand what the rules are, but these things are dynamic. Calling a marked unit, he could have been around the corner. He could have been a half hour away. There's no way you can put a time frame on patrol response, not today.
Right.
So, okay, thank you.
All right, we're going to go.
We put the discipline grid up there just for your own edification.
Okay, we're going to go to Member Spencer and then Member Holloway.
Thank you. To me, hearing the facts of this case just feels like an egregious kind of escalation. So I'm listening through your comments and your line of questioning. I think the thing for me is it's still, as I imagine the scenario, it's late at night. She's with her son. She's got this car that's been following her for about 10 minutes. They might have flashed a light for a couple seconds. I know there's some ambiguity around some evidence there, but flashes it, stops. flashes it, stops. She could have literally no idea what's going on. She's just trying to get home with her son. So, and they had other options to use. So to me, it makes no sense why they called in aviation over a car with expired tags. That also just seems like a huge misuse of funds. It makes no sense. And again, with it being later at night, that just makes her probably even more scared. So I don't understand how anyone can kind of, I don't know, I can't fully comprehend a full defense around that without taking that into account for her and her situation as well. So whoever she is, because she probably was really afraid, and that could have gone dramatically worse. Something else could have happened. If they had come out a certain way, she could have come out a certain way, people could have died. And it was because we did not pick different options in trying to engage this person. So perhaps maybe if it was the siren, maybe if there was using like the mic, trying to speak to this person and not just waiting until this last minute and coming out guns drawn. I think that this entire situation could have been avoided. And just even from our conversations around the dismissal of the case by the prosecution, it feels like there was good reason that we might not necessarily be privy to at this moment, but it feels like there was very, very good reason for this case to have been dismissed in this way and for her to kind of get at least some aspect of the justice that she was denied in that moment. And I do also think it's really interesting to note that this case was back from 2019. So this happened about 4 years ago. 4 years ago. So it feels absolutely wild to still have, and I feel like it should be incredibly traumatic for this person to have still gone through this entire process in its own varieties again and again. So for me and where I stand and where I sit right now, I would love to hear any other comments, but I really do side with the understanding that this should be sustained and there should be more disciplinary action to this. I understand that they currently have no other disciplinary moments on the record. However, I think that this still stands as something pretty significant that we have to address.
All right. Member Holloway.
I'm just wondering, from the distance that it took place, was the camera activated? If it was not, then if it had been, it probably would have shown where she almost hit a pedestrian.
Yeah, in 2020, they may not have been issued.
Yeah, they didn't have one at that point.
2019.
Yeah.
She didn't make the report to us until 2022.
Yeah.
So I don't think they're undercover, yeah.
And, like I said, her major concern was her child, trying to, and you get out drawing guns on you, I think it's kind of escalated what really happened, and so she didn't know the police interfere in her life, more or less, That's how I see it, And what you recommend them for the disciplinary thing, I think is really light. But we can accept it, it depends on the board, but it really light, because as they looked at the case and they got further off in the court system, they dismissed it.
Mm-hmm.
And so there's some reasons why they dismissed it, so.
Well, the one-day suspension is at the top because they didn't have any of the previous disciplinaries pending related to that. So that's, if you look at category D, it's a 1 to 4, and I chose the least amount and give you the option to
Well,
review it and make a decision.
I make a motion to accept your,
Okay.
All right. I have a motion, and it has been seconded. Second. All in favor? Any opposed? No. All right. That was a no. All right. The motion has passed. I would like to make a comment regarding what it appears to be as excessive. I think the policies matter. right? Like we wouldn't, if we didn't follow the policy, why were they written? And if it is calling for a marked police car, right, then that's what should have happened. We went all the way to dispatching a helicopter and, signaling aviation when we could have simply followed the policy. And so I think that's problematic, but it also points to our use of force report, right? And it backs that research that we have provided and has been recently disseminated to the Nashville community that I believe we all need to review because this case speaks to, right, the excessive use of force.
And I will add the location, as he mentioned earlier, on where this occurred. I think it was an escalation to call a helicopter. And I don't know if the two correlate because it was in the Bordeaux area, coming down from that way or not. I'm not saying that. I'm just saying as we look at the totality of the circumstances, would they have called a helicopter if this was in a different location? I don't know.
Remember when?
Yeah, just one last thing. I absolutely, positively understand the fright of a woman late at night pulling over for any reason whatsoever. Now, the policy allows for the person a reasonable time to pull over, and she eventually did. Any police officer would tell their family members to do the same thing.
That's right.
Right. The biggest part of this, in my mind, is that she was charged with a felony in a non-moving violation traffic citation, and she had 13 court appearances. And I'm not picking on lawyers, but you can't get a lawyer in this town for one hearing without $5,000.
That's right.
Correct. And missing work.
Right. So, and we're not judging that part of this case. I got it. It just seems to me that this woman, trauma is an understatement. Now, I understand also the officers being concerned that it may have been a stolen car. It didn't stop. They may have thought that why they notified aviation. But I would have liked to have seen a tighter timeline from the time they got the notification from dispatch from the time she stopped. To me, as an officer, whether you're plainclothes or you're a uniform officer, that would have been reasonable in my mind if we saw a closer timeline. So I'm just trying to explain my reasoning. Okay. Thank you.
All right.
No other questions? I'm moving to inside her home in executing the warrant. The policy violations are MMPD Manual 4.20.050, care of property, other property. Manual 4.20040H, honesty and truthfulness. And then, hold on. Okay. The findings of fact in this case. On March the 8th of 2022, Sergeant Officer 1, Officer 2, Officer 3 arrived at the complainant's residence to serve an outstanding warrant on the complainant's son. Body-worn camera shows officer arrive at complainant's residence and announce on a PA system for complainant's son to exit the home. Body-worn camera shows complainant exit her residence and makes contact with Officer 1. Officer 1 informs complainant why officers are at her residence and that they need to serve the warrant on the complainant's son. Body-worn camera shows complainant on the phone with her son and instruct him to come outside. The officers inform the complainant that they need to come inside the complainant's residence to ensure that no one else was inside, to make sure that minor children who are inside are safe. The complainant eventually consented, allowing the officers into her home. She follows them inside. The body-worn camera shows Officer 1, 2, and 3 and the sergeant. They conduct a protective sweep of the complainant's residence. The officers can be observed going upstairs and enter the second bedroom. Body-worn cameras show that as officers enter the second bedroom, a television is lying face down on the ground. There is also visible damage to the blinds on a window in the corner of the second bedroom. The body-worn camera of Officer 3 shows that Officer 2 and 1 and the sergeant, they stepped over and around the television lying on the floor to perform the protective sweep of the residence. The body-worn camera shows Officer 4 enter the residence with complainant and another plainclothes officer after the protective sweep is completed. Body-worn camera shows Officer 4 accompanying complainant as they locate a firearm within the residence related to the warrant for the complainant's son. The body-worn camera shows as Officer 4, complainant and the plainclothes officers leave the bedroom where the firearm is located. The complainant shouts and walks to the second bedroom, followed by Officer 4 and a plainclothes officer. The body-worn camera shows the television is face down on the floor. The complainant lifts the television to an upright position. Officer 4 states, "No, is it broke?" To which the complainant responds, "They broke my mama's TV." Body-worn camera footage of Officer 4 shows the complainant picking up the television from the floor where the damage is visible on the screen of the television. The camera shows the plainclothes officer inform the complainant that officers will fill out a report for the broken television. Officer 4 completed the legal intervention form associated with damages for the television and gave the incident report number to the complainant, instructed the complainant to call later for a claim for the damaged television to be processed. After March 8th of 2022, after that incident, the complainant spoke with MMPD personnel who assisted her with processing the claim. The complainant spoke with representatives of Metro Legal, who informed the complainant that a payment was being processed and would be sent to her. Emails from the Metro Claims representative show that a claim for compensation was processed and approved on March 24th of 2023. So discussion and analysis, the care of property. While photographs of the television show that it was clearly damaged, body-worn camera and other available evidence does not show that the damage was a result of the officer's willful or negligent act of omission as outlined in the policy. Officer 1, 2, and 3 and Sergeant were in full raid gear conducting a full protective sweep of the residence while serving a felony warrant. The body-worn camera shows that the television was face down on the floor when Officer 1, 2, and 3 and Sergeant entered the bedroom. It shows them attempting to step over the television. The body-worn camera shows Officer 2 stepping on the back of the television to gain access to a closet. It is uncertain whether this act alone caused the damage to the television or if the television was already damaged when he stepped on it. Regardless, Officer 2 on stepping on the television is not negligent in light of all the circumstances. Honesty and truthfulness. Here, Officer 4 stated during her MNCO interview that when the complainant picked up the television, she said it was damaged. I did not see the damages. She just said it was. This statement is false and contradictory to what can be observed on the body-worn camera footage. Body-worn camera footage from Officer 4 clearly shows large cracks across the screen of the television when the complainant lifts the television. Further body-worn camera footage shows Officer 4 and the plainclothes officer react to the damage done to the television. This statement provided by Officer 4 in her MNCO interview is false. By the preponderance of evidence reviewed, the executive director concludes that the allegation of care of property against officers 1, 2, 3, and Sergeant is not sustained. By a preponderance of the evidence reviewed, the executive director concludes that the allegation of honesty and truthfulness against Officer 4 is sustained. The recommended action is Officer 4 is no longer an employee of MMPD and therefore no action can be taken. However, if that officer was still on the police department, the violation of honesty and truthfulness is a category AA offense, and that disciplinary action is dismissal, as according to the discipline chart. That concludes my review of that, and I'll take any questions. Okay.
Member Spencer.
Thank you. Very quickly, do we know if this person is an officer in anywhere else in the country?
I think maybe in Florida. Was this the officer in Florida? Yeah.
Turn on your microphone, Dave. Your microphone.
Yeah, we know that officer moved to Florida, but I do not know if they're still an officer. I don't think they were, because there was actually a previous report that involved the same person. But that is worth checking on. I can try to figure it out. I think when we had looked, the same officer, and this was months ago, I think we had looked at that time and they were employed in some civilian job. Because I think it was kind of like they just left law enforcement altogether, but we can double check that. I can try to figure that out.
I would like that. And
Yeah.
can we also determine, so when exactly did they leave MNPD?
I can look that up, but it'll take just a sec.
While he's looking it up, did he have a question?
Was the people at the residence, was they compensated for the damaged TV? Okay.
I don't know if this is a question that you all can answer. I'm just curious about the time that it took for them to be compensated. It was like over a year, right? Do we?
It's just been months since I looked at it. I don't remember why. I certainly remember thinking that the complainant was frustrated and expressed frustration, and I certainly shared in that frustration. But I wasn't surprised either about the types of delays. I think, again, the headline for the story for me was the officer lying about the damage that she witnessed on body-worn camera that we captured, thank goodness. That seemed pretty egregious.
Thanks.
Member Spencer.
Oh, I currently don't have any more questions right now, but I think that is one of the things that's on my mind, just getting caught in the lie, which is why I'm pretty concerned if they are an officer somewhere else. And I think to sustain an allegation of breaking honesty and truthfulness, to me, although the body-worn camera footage, and I understand why it's not sustained, it does give me pause to kind of question a little bit of the situation. But I don't think we have the evidence to kind of go around that. And so it just gives me a lot to pause and think about.
I'm sorry, that was the part that I'd forgotten about. Again, it's been months, but it occurs to me now. This was a case that was reviewed by Metro Legal. How Metro Legal also, for this period of time, did they speak to any of the police officers involved? Did they review any of the body camera? The fact that they also did not, I can't say if they didn't see it or if they didn't try to look at it. There's something called burying your head in the sand. That really bothered me. That, of course, we are looking at MNPD's policies and reviewing whether the police officers committed misconduct. I'm not suggesting in any way that Metro Legal committed misconduct. I just think that there's something pretty wrong with a process when they are being asked to look at damage done by a Metro employee, and this isn't coming to light. That something this egregious isn't being found. So I'm sure glad that we were there to see it. So.
Yeah, I think it comes down to accountability, right? And so that's what I'm hearing. That's what I'm seeing. I think from Metro, and I can't speak for Metro Legal, but I mean, are we looking at them trying to rectify it with compensation? Or are we talking about getting down to the bottom of accountability with MNPD and looking at it from a perspective of analyzing the policies and, lending our recommendation of a violation, and then we find that honesty and truthfulness is being violated by an MNPD officer, and the only way, let's just say, that comes to light is through the COB, right? Because they got a new TV, but who analyzed this case to say that a violation of honesty and truthfulness, and the only remedy for this is a category AA offense, and it is dismissal for honesty and truthfulness. Like, the only option for something egregious, as Attorney Yoon has stated, is dismissal. And I think that's pretty telling.
I think so as well, and especially if we get into the context, this is about property, for which there's a process in which it can be repaid. We can get a TV again, but if you're going to be untruthful in a case around property, what about a case when we're talking about people's lives? That is a big concern, and so for me, what I would really like to figure out is if we can amend this to also, if we can determine that they're still on the force somewhere else. I think, and we agree, and we have a consensus that this was an egregious moment of just mistrust that we ordinarily would say is ground for dismissal, that we should talk with that department that they've moved to. I think it should be within our rights to at least have some conversation, that this is what we as a body have decided upon, given the evidence, and that we have some major concerns. And what would also be helpful, it's still with that in mind, is determining when they decided to leave MNPD, because again, it's fine if not, but
yeah, I have their start date, but at the time, the employment records that we have, the copy that I have doesn't list the end date, unfortunately.
We can ask, see what happens. I think all of this also, as it pertains to property, I know this is a little offbeat, but I also am concerned because when you get complaints about what happens if Metro Legal took that long to pay for a television? What happens when somebody's door is kicked in and their door is off the hinges, and then, who repairs that, and how do they sit in their house? I'm thinking about a case we had a few years ago where a woman's, they banged, did the whatever you call them thing, and, went into her home and left her door on a warrant, on a knockless warrant at that time. What happens, I remember her saying that her door was like that for days. Is it the responsibility of the police department? Is it the responsibility of Metro? Is it the responsibility of MDHA? Whoever. But who handles that? Because that's still a damage to property. So, all right. Oh.
Member Goddard.
I'd like to make a motion that we approve the report as presented with an addition for a recommendation that to the chief that he ensure that the personnel record for this ex-officer includes a copy of this PRR, and that it is forwarded to any other law enforcement authority that requests a copy of the department's personnel records.
Second.
That wasn't my best stated motion, but you get the gist of it.
All right, all in favor?
Aye.
All right, motion passes. Member Brown, did you have anything that you want? You're good.
I was about to make the exact same motion, but couldn't have done that fast.
All right.
We're right there.
Okay.
Right. This is case number CC 2022-19. On May 3rd, allegations of misconduct is against Officer 1, deficient or inefficient performance of duties. Against Officer 2, deficient or inefficient performance of duties. Against Officer 3, deficient or inefficient performance of duties. The summary of the complaint allegation is on May 3rd, 2022. The complainant called 911 after hearing gunshots and screaming outside of her home. Approximately 30 minutes later, the complainant observed an MMPD officers drive by the area. The complainant did not observe the officers exit the patrol vehicle or activate patrol lights. At approximately 11:15 p.m. on the same night, a neighbor observed a dead body on the porch of the house directly across from the complainant's house. The decedent died from gunshot wounds to his lower body. The complainant believes that the decedent could have been saved if Officer 1, Officer 2, and Officer 3 had thoroughly investigated the call. The policy violations here are deficient or inefficient performance of duties. That is 4.20.050F as in Frank. The findings of fact on this case is on May 3rd, 2022, the complainant observed 10 to 12 gunshots outside of her home. Complainant called 911 at approximately 9:26 p.m. to report this incident. Dispatch audio shows the complainant tell 911 that she observed gunshots and screaming across the street. The 911 operator told the complainant that an MMPD officer would be sent out immediately. The CAT reports show that Officer 1, Officer 2, and Officer 3 were dispatched to the initial 911 call. No body-worn camera footage for Officer 1, 2, or 3 was provided by MMPD, nor did Officer 1, 2, or 3 consent to be interviewed by the MNCO. Approximately 30 minutes later, complainant observed an MMPD patrol vehicle driving by. The officers were not observed getting out of the vehicle, activating their lights, or taking the time to investigate. Complainant observed the patrol car drive by. The complainant exited her residence to discuss the incident with neighbors and how the MMPD officer did not fully investigate her initial 911 call. CAT reports show that at approximately 11:05 p.m., a neighbor called 911 reporting that gunshots were observed approximately 30 to 40 minutes prior and that he observed a body laying with blood on an adjacent front porch. The neighbor says the body appeared to be unresponsive. CAT reports show that an ambulance and MMPD officers arrived 1 hour later. Body-worn camera shows the decedent was slumped over with his back against the front door of a house facing the street and within direct view of the street. The decedent is clearly unresponsive. The body-worn camera shows the decedent is surrounded by a pool of blood around his legs as officers and other first responders arrive. Body-worn camera shows the officers who responded to the second 911 call and other first responders immediately rendering aid to the decedent. Officers declared decedent deceased after attempts were made to render aid. The body-worn camera shows officers begin to investigate the scene as a homicide. All right. So MMPD policy requires that officers render first aid if officers encounter an injured victim or of a violent crime or any of it. It says violent, sorry. Or any other emergency situation. They also have call-out procedures, which generally require officers to request investigative support from homicide detectives, missing person detectives, or detectives from other required departments when there is a known victim. In this case, the initial shots fired call only alleged that the complainant heard the gunshots. At the time the complainant made the phone call, there was no reported victim. Witness interviews showed the area was dark at the time and that street lights were not well lit and did not provide enough light for the decedent's body to be seen. The MMPD's refusal to provide the body-worn camera footage of Officer 1, 2, and 3 and refusal to allow the MNCO to interview these responding officers have left us with insufficient information to determine whether Officer 1, 2, and 3 were deficient in the discharge of their duties of responding to the shots fired call. It is unknown if there is any other information that they were aware of before or after responding to the call. It is unknown whether the decedent's body was visible to officers as they drove by the house due to MMPD's refusal to release the body camera footage and other pertinent documentation. It is unknown what measures Officer 1, 2, and 3 took to investigate the shots fired call due to MMPD's refusal to release the body camera footage and other pertinent documentation. Further, it is unknown whether Officer 1, 2, and 3 were deficient in their performance and investigation of the shots fired call, and whether the decedent's death could have been prevented by a thorough investigation by Officer 1, 2, and 3, which would mean calling out medics to perform some type of support for that person due to their lack of cooperation with our investigators. The incident address is located in a majority Black, majority impoverished, and historically over-policed zip code in North Nashville. This zip code was identified by the Brookings Institution in 2018 as having the highest incarceration rate of any neighborhood in the United States. It is concerning that in an area of such police scrutiny, officers did not perform even a rudimentary investigation. Further, it is disturbing that MMPD has refused to cooperate with providing the MNC information for this case. So the conclusion is there is insufficient evidence to determine whether or not the allegation of deficient or inefficient performance of duties should be sustained against Officer 1, 2, and 3. And the recommended action is that pursuant to the rules of the Community Oversight Board, Section 2C1H, the board determines whether the officer's failure to respond to the shots fired call warrants a referral to the Department of Justice.
All right. Member Goddard.
I'll take any questions.
All right. Yeah, let me say I've got a problem with this I'm going to describe in a proposed solution. And I've discussed the issue I've got with both Legal Advisor Yoon and also a lawyer, Assistant Director Keeley, so they may have comments. I understand the concerns. I understand the desire to want to know a lot more about this. I understand where we are with Metro Legal's advice. My problem is the recommendation for referral, or the discussion referral to the Department of Justice. The cited section of our rules and the corresponding charter provision, which has very similar language, would require a finding of criminal misconduct before making any referral, and then would limit a referral to the local prosecuting authorities, the district attorney, the U.S. attorney, or the grand jury. So I don't think, for at least those two reasons, we have the grounds for a referral. The information we want is blocked by Rule 16 of the Tennessee Rules of Criminal Procedure, and the gatekeeper for that is District Attorney Funk. And what I would recommend, not making a motion yet, I'm not trying to preclude discussion or anything, is that instead of referral to the Department of Justice, we direct staff to pursue with District Attorney Funk whether he will allow this requested information to be provided. He can take documents and say, I'm not going to keep them privileged under Rule 16, particularly because our requests for them were made before the July 1 deadline, where everything changed because of the effectiveness of the new state statute. That's a lot for a lawyer to get their hands around. It's a lot for a non-lawyer, especially to get their hands around. So if there are questions on that, please let me know or direct them to the other lawyer folk here. But I'll ask you, Jill, Director Fisher, does that make sense?
It does. I mean, we haven't made any recommendations directly to General Funk. I mean, I don't have a problem with that. If there's anything else that we can add to that, would we? I mean, we don't really have a procedure for that because we haven't had to do that.
Well, I'm making it up.
Yeah. Okay, yeah. Yeah, but I mean, I think that makes sense. What about?
I mean, I think we can definitely request it. We did request a lot of stuff from them recently, and we were blown off.
Say that again. I'm sorry.
We did request. I reached out to the senior leadership of the DA's office a couple weeks ago about trying to get, or maybe 2 months or so ago, trying to get some of the TBI files in some of the officer-involved shootings, and was pretty resoundingly denied that information. I was sent the public to their press page. So
I mean, well, the other option with that,
we can ask them.
Yeah, we can ask them, or we can just ask. I mean, I think that they have a grand jury convened, and that grand jury can request this information. I mean, I would like to do it in that regard, like go to flunk first and then the next step to the grand jury if that doesn't work. But I don't know how that operates either. I do know that there's a grand jury that's in session now.
I would say, I think we have plenty of authority to go ask a question of the district attorney. I don't think we can go ask questions of a grand jury. I think we could make a referral to the grand jury if we had the required finding, which we don't have. So that's why I recommended what I did.
Member Spencer.
Thank you. Can anyone explain what the department's reasoning was for refusing to let us see this body-worn camera footage?
What, the police departments?
Yes, what was the reason why? Since
that is going to what Board Member Goddard was saying. So the police department's position has been that they cannot release anything to us after July 1 pursuant to Rule 16. I think that is a semi-accurate statement. If they were interested in renewing the MOU, that problem could have been solved on July 2nd. But that is their rationale, is that they are saying that Rule 16, the rules of discovery do not allow them to release this information to the public. And that is true, but that ignores the fact that the statute that brings the CRB into existence also allowed them to, the same provision to release confidential material that we had previously. They just don't want to talk about that. So,
and then I just want, for people who are listening in, Rule 6, this is because this is still an open case. It's a potential homicide case that is pending. And so that's why the Rule 16 issue, I think, comes into place. So just for people who don't know what that means.
Mm-hmm. All right. Member Beard.
Thank you, Madam Chair. Do we know if the police department is investigating the actions of these officers? Are they undergoing their own investigation?
I mean, I'm not sure of that. I mean, I would assume that I don't even know if has the homicide been closed? Do we know anything about it? We don't know much because they wouldn't release anything to us. Mm-hmm. I mean, there might be some, I mean, we don't know who, at this point, even who the decedent is, do we?
Only from news articles, but we can't really use that in this context. So, yeah, really short on information on this one.
Understood. Thank you.
Member Spencer.
Thank you. So we don't even know if they've had other like disciplinary actions or deficiencies in duty before. We don't know that at all. Okay.
Member Nguyen.
Yeah. So, and what would the deficiency be? That's my question. Because let me give you a little more context. You could probably sit on any back porch in the city of Nashville at night, and I do it regularly, and hear gunshots being fired almost every night. And the response is a car arrives and drives through unless there's something obvious in front of them that they can see. That's about all they can do. So in this case, we're saying that they didn't have a call for a body at a specific address to examine. All they had was shots fired in the neighborhood. They arrived and drove through the neighborhood and left, and the secondary call was the neighbor then discovered the body. So and I know we'd like to see the body camera footage. That bothers me more than anything else, that we're not being allowed to do our job. But that's another day. But for the officers that responded, what rule would they violate?
I mean, my answer would be I don't know, and part of the problem is we don't know what we don't know, right? Because they're not giving us anything, and so I'm not saying I cannot say the officers were deficient. I'm not saying the officers were deficient. I am saying the department is uncooperative because the concern from the complainant was this gentleman was shot in the legs, and the news story seemed to make it sound like he was shot during a robbery in an adjacent alley and made his way to the porch. And so there is every likelihood that when the second group of officers, the one that we don't have information for, that when they responded, he may not have been on the porch at that time. And so we really absolutely should not hold that against them. But the problem is we don't know, because we don't know what information they had. We don't know if somebody was yelling, hey, Mr. So-and-so is missing, or he's over here, or anything. We don't know what information they had, what information they didn't have. So you're exactly right. I mean, we can't make that determination, but that is it does stick in my throat that the reason we can't make that determination is because MNPD does not want to give us anything.
When you say MNPD, who at MNPD?
I mean, the records denials come from the records department, but I think we can all be confident the records department is not the one making these decisions. I think they're coming from higher up.
But we don't know who in the police department is not allowing the Oversight Board to see body cam.
We know from our last conversation with them, which was with their legal representation when I was emailing them asking about the MOU. So, I mean, I can certainly give you those names. I mean, I had raised that issue to them quite a while ago.
And I will say, remember when that is a good question, but I will say that we have raised this via email and when we correspond to Chief Drake, right? And not only have we notified Chief Drake that we are not getting any cooperation and that Commander Laura stopped attending the meetings, we've notified Metro Legal of MNPD's on cooperative spirit as of July 1.
And that would be Metro Legal Attorney Cindy Gross, who is the legal representative for the police department as well.
And Gilder.
I will say that one of my concerns with this case is that this happened, there's gunshots in a neighborhood that is historically Black African Americans. And the fact that, it can be, and I can attest to that as a police officer myself in Southeast Washington, D.C., that you hear gunshots and you just get accustomed to it. Mm-hmm. And so, but what we don't want is that to continue to happen. We want officers to drive through, to be diligent, to get out their cars, to ask questions, to call others in. And that did not happen in this case. That's all that we do know that happened. That did not happen. The officers drove through, they heard the gunshots, and you can just become very numb to things that happen and reoccur. And we would hope that officers would, when they hear gunshots, since they pay so much money for Shot Spotter and all these other technologies, that they would take in consideration that sometimes, or possibly, unfortunately, a body could be attached to that type of gunfire.
No, and I agree. You should never be accustomed to gunfire. Did the dispatcher tell the complainant that the officers would meet her to talk to her about the gunfire in the neighborhood?
I don't know.
So they had nobody to talk to then. No door to knock on. Other than their presence in the neighborhood could have deterred more gunshots.
They had the caller. I mean, the caller did provide an address, and I believe she said she was right across the street or something. So, and then the neighbor who finds the body actually wasn't a neighbor; he was a guest, but he came out to smoke a cigarette, and he was also, right in the area. Right. So they did have a house to knock on the door of, for what that's worth.
Member Holloway, and then Member Beard.
We had an incident that happened, and you have to really take I know that the zip code was 3728. I know that for a fact. Mm-hmm. The time that this occurred was pretty close to the shift change. Mm-hmm. And had a lot to do with the response time and who responded. And it still could have been the evening shift. Usually you got roll call at 10:30, and then that C shift come on about 11 o'clock. So you got a lot of things that happen in between there where people exchanging cars, and you got a bag up. So when when you're changing shifts, you could have 30 or 40 cars that backed up. And so we had to take that under consideration. But yet and still, you got to take your job as important, protecting the neighborhood as opposed to the neighborhood that you live in yourself. And a person, the victim that was shot may have not been when the calls went out, but it happened in that area. And sometimes you have to use extra caution to try to seek and find the solution to the problem. And a lot of times, people that call in, they want you to answer, see what's going on, but they don't want you knocking on their door and bringing the problem to their house, you know. And it might have been a different story, you know, because I had that experience. They said, well, I told them not to come knocking on my door because they worried about somebody shooting at their house. But yet and still, you have to not look at the zip code area, you know, say this happens all the time, you know. You hear shots throughout the night, you know. So, but this is just a particular incident where somebody did get shot, and the body was found later. But you have to look at the time that it happened.
Thank you for that perspective. Member Beard?
I share the same perspective as Member Holloway, because it seems to me that it's two incidents here to me. Is that we had one incident that was gunshots, and a call was made at 9:26 p.m. And then it took the officers about 30 minutes, I think the facts show, to come out to that, based on that call. And then another call came at 11:05 p.m. saying that the gunshots were 30 minutes before. So we're talking about a matter of 30 minutes between that, right? So if it was 9:26, they came out 30 minutes, that's about 10 o'clock. And then if they said that they heard other gunshots, they called it 11:05, said they heard other gunshots 30 to 40 minutes before, we're right at 10:30. So that's what I'm reading in the incident. Is that right? Because
I was going to say, I know, and Dave, correct me if I'm wrong too. I was going to say, I know that
I'm looking at number one and number.
And just to clarify, the second phone call was fueled by the neighbor had stepped outside and saw the body, and then mentioned, I heard gunshots about 30 minutes, 30, 40 minutes.
It's the same incident.
So it's the same incident.
Same hearing of gunshots, she just calling twice.
They just have different, I think that they just have different perceptions as they're talking. Because remember, this happens in an alley, and then they hear the gunshots, and then sometime later they see the body.
And then they're saying it's because of the gunshots.
So they are kind of like saying it's,
I just want to make sure I was reading that right, because I'm just reading 1 and 8 and trying to.
I think the time is a perspective issue.
Okay.
There's no direct.
Okay.
And it sounds like that from that experience, from the 9 o'clock call, hearing the gunshots, police riding through, didn't get out. Nothing really was a result of that, right? The desensitizing of gunshots, because this is what we hear all the time. And then seeing a body, right? And making that correlation of the gunshots and then the body on the porch. Then that's how we get to the 2 phone calls and then this complaining now saying that the police didn't do something.
Correct, and I agree with that. I mean, that was my next point to make. The concern that I have is that, I guess, if an officer has a call, comes to a location in which an individual has called and heard gunshots, they said they heard gunshots, what is the obligation of the officer at that time? So that's my major question here, because what they're saying is they drove through. The concern was that they didn't, stop the car, look around. That's what I'm trying to understand. What was their obligation when a member of the public called in and said they heard the gunshots? I know they should come. I know they at least should come. But what is their obligations once they get to the scene?
So let me read what this says in the any other questions? Thanks. So it says MMPD's policy requires officers to render first aid if officers encounter an injured victim of a violent crime. MMPD 15.30.010C, or in another emergency situation, MMPD 18.160.040. MMPD also has a call-out procedure, which generally requires officers to request investigative support from homicide detectives, missing persons detectives, or detectives from other required department when there is a known victim. In this case, the initial shots fired call only alleged the complainant heard gunshots, and at the time the complainant made the phone call, there was no reported victim. That came afterwards. So that's all we have on that. I don't think that there is any explicit policy regarding that.
Because at that time, no one had reported to the police officers that they saw a body.
That's right.
At that time, that they only reported that they heard the gunshots.
Is there
and
a
I'm just
policy that
trying to understand what the officers' obligations
relates
were
to
when they first came.
investigation? Go ahead. Danny?
I just want to point out that it's been said, there's been presumption given that the police officers actually did show up, did do a thorough investigation of responding to the call, and I don't think we can give that presumption here. We have had a process for several years now where if evidence is available to view, like body-worn camera and witnesses to be interviewed, like the subject officers, that we do that, and then we will give a presumption to what is being said to us or the camera views that we're seeing. Similarly, when somebody comes to us with a complaint, we're going to credit that. We're not going to just assume it to be false and just say someone's, nothing's been, that this is just malarkey. No, we're going to accredit a complainant who comes to the Community Oversight Board and makes a complaint. We're going to thoroughly investigate it when we can. And I'm with Mr. Kiley here that this is just a glass half not transparent to me, that we have confidential information now from the police department that we are not sharing with anyone, and that Metro Legal has continued to allow us to do our job as a Community Oversight Board. And yet we have this other party that we've been doing this with for several years who's just stopped doing it, who stopped cooperating. In one lens is giving us this confidential information that should we just be destroying it now, or should we just have destroyed it back on July 1? I think we're entitled to look at this, and until we do that thorough review, we have an example not 30 minutes ago where what we've read in a report turned out to be completely false. So yes, we have a report that says 3 officers went and did a maybe thorough investigation of the complaint that came in, but I don't want to accredit that without looking through evidence that we know exists. We have video and we have witnesses who were supposed to have been there who may have a memory that is different. Did they drive through and say, oh, there's a black person on his porch who's got gunshots? It's probably nothing. I don't know that. I think it would be nice to see that, make sure that what's reflected in these reports is actually accurate, rather than just assume they did a good job of investigating this, when we know that not an hour later, a dead body was on this porch, which seemed to be maybe in clear sight of the street.
Member Brown.
I guess, I think Member Goddard has put his finger on the issue, and I'm not sure what really we can do. One thought that crossed my mind is, given the lack of information we have, is it possible for the board to refer a complaint to OPR for an investigation as to whether the first set of officers, and that's really the only ones that are a question, once they had a body, everything went as you would expect. The problem is you have the question of whether or not there was a thorough, a proper check of the first officers that drove through. And I just wonder if we'd be better to refer that to OPR and/or the district attorney for such further action as may be appropriate. I think we're really handcuffed as to what we can do.
And you know what, Member Brown, it may be the intention of MMPD withholding evidence and or supporting information for us to make that assessment. which does handcuff us. And so that may be part of the bigger issue in who we contact regarding this case. I'm going to go to Member Spencer and then Member Goddard.
I would also like to add, I think just at least for the record and for people watching at home, and I know we've had our own issues and when it comes in terms of our timeline and things, but we also received this complaint May 4th of 2022. And now because of different rules that are being put in place, we're being told that we can't get the information we need to finish out an investigation, which if we're talking about having cooperation between agencies, we're talking about having these conversations in good faith for something that we've been working on for so long. It would make sense in good faith to allow us the information that we need to be able to make our determination for what we can't do. So I think for the public, I think for us as a body, moving forward, it's very telling that we're again getting stonewalled and not being allowed to effectively do our jobs and not getting the information that we just need to be able to make certain determinations. I think even when we think about just final recommendations, it seems outrageous because there's so many assumptions that we can make that we just don't have the evidence to make. So I'm really truly leaning on we have to figure out some sort of way to be able to get this sort of evidence that we need, and preferably before we're officially reconstituted, if at all possible.
Okay.
Real quickly, it strikes me we've got two issues here. One is what was just addressed for this specific case. More broadly, how would we like, what does this board and the reconstituted CRB want the policy to be when officers are dispatched to shots being fired? And that's more of a policy issue, and that's something the CRB will have the authority to make recommendations on. So I believe those of us that will continue on have, well, even at my age, will have enough memory to be able to remember that and pick it up and run with it starting at the end of this month. That addresses the policy. For this specific case, I still have the motion on the floor. I think it's the correct thing for this specific PRR.
Yes, so I wanted to make sure that we understood, what we were doing here, and number one, what we said we would do as far as the policy when we need additional information and additional answers. And so are we saying that this will be referred to the district attorney's office for additional information? I need to get clear on what we're asking here, because I know we don't want this to sit with us, right? Because of the lack of cooperation from MNPD. Does the MOU state, and then what can we agree upon?
Well, the MOU, and guys there at the end of the table, correct me wrong, the MOU, the police force safety condition, is no longer in effect because it was based in part on the statutory obligation of the Oversight Board to maintain information we were given as confidential. And that went away when the state legislature changed the statute. So their position is, and Metro Legal has agreed with them, that the MOU is not effective with respect to these Rule 16 pieces of information. My motion was not to accept the PRR recommendation of Referral Department of Justice, and instead to direct the staff to communicate, to engage with the district attorney, indicate this is a board request and board decision, that we would very much like this information that was requested well before July 1 to be provided, and we believe the district attorney has the authority under Rule 16 to permit that to happen.
Member Wynn?
One quick comment. Member Goddard, are you saying that Metro Legal has instructed the police department not to cooperate with the Community Oversight Board?
They have given them legal advice that winds up there. They have said they've looked at the MOU with the tri-party. There are two MOUs. Having looked at the tri-party MOU, which is between the Oversight Board, Metro Police, and the district attorney, and having looked at the issue of where is that now that one of the things that is pointed to in that MOU stated to be the basis for it no longer exists as a matter of law. Is that their interpretation? Do they agree with the police that all of this information is now covered by Rule 16, and there's no exception unless the district attorney says, yes, you can give them that. And Metro Legal did agree with the police department on that.
So even if the police department wanted to give the information, they couldn't because they're following the orders of Metro Legal by not cooperating with the COB.
That's where they are today.
Okay, thank you.
Let me correct something. At the board meeting, the word was not, wouldn't stated that cooperate. It just said not to release certain documents. He said he didn't want us to get confused. They didn't encourage the police department not to cooperate with us, but just not to release certain documents. That's the key thing that we discussed.
Mm-hmm. So does that confuse you even more, Member Wynn?
Yeah, I am confused. Cooperation is giving us information so we can judge whether these officers are negligent in their duties.
Mm-hmm.
That's cooperation.
That's right.
I'm sorry, I didn't mean to raise my voice, but it just seems ridiculous.
Mm-hmm.
I agree. I mean, how can you accomplish your task without evidence?
Right.
If the legal department says, don't give them evidence, that is your answer to our question. We've been talking about this for the last 20 minutes. The answer is Metro Legal does not want the Oversight Board to see this evidence. So that my question's been answered. Thank you.
Well, that's basically what we discussed at the board.
Turn your microphone on.
The word cooperate was the key thing that he
That's right.
discussed. Is that
That correct?
And that's what I heard. And but he said, don't y'all leave out here confused. We didn't say not to cooperate, but just not to release documents.
And so to Member Holloway's point, Member Wynn, it was that sort of convoluted answer of cooperation and not releasing information that was prohibited by the new law. Right. And so, it was a lot of discussion around, well, then how do you weigh cooperation? And then where is the cooperation coming from? And how can we trust any one in Metro Legal if their advice to another Metro department is not to cooperate with the Community Oversight Board, which is also a Metro department? Who had their hand? Member Brown?
Well, I think we're getting wrapped around the axle on the word cooperate. Metro's legal opinion was that because of the statute, they cannot release it. Now, the effect of that is that we're left in the dark, but it's not that they're saying don't cooperate with the board. They're saying legally you may not provide this information. Metro Legal has given a legal opinion that, as I understand it, that because of the statute, they can't legally provide it to us. And of course, the result of that is we're stuck. I think we're getting wrapped around the axle on whether it's cooperation or not. It's a legal result, and the end result is we're left in the dark. That's true. So the question is, what can we do in this case?
Right.
It seems to me we could refer it actually to OPR as to whether there was appropriate action. We can refer, as Member Goddard had said, to for his motion, and I think that's about what we can do, and we may have the right as the review board to make some policy discussions as to what should happen in this situation. I mean, it may well be that if we got the body camera, or at some point we do get it, that the officers, made an appropriate sweep for shots fired, and because once they actually had a report of a body, everything there seems to have been performed properly. The real question is just whether those initial officers, with the shots fired, whether they failed to do anything or not, and that's something that at this point we just can't determine.
I also think, and AD Kylie, I'm coming to you next. I'm sorry, Attorney Yoon. And I also think that with this new law where it prohibits us from receiving confidential information or whatever it is, it does not. Let me turn that around. We can receive it, we just can't disclose it. How tell me, okay, explain to me how, because I know for a fact, even though we have public, we have to have public information, correct?
That's all they saying that they're going to give us.
Right. But if we receive additional information, doesn't that have to stay confidential?
No, because we're only going to be giving public information. So I will also draw a distinction. They're saying this after October 26th. We cannot receive anything but public information.
Right.
So currently, and this is what I was kind of whispering to Mr. Kiley, is that the same authority that I think allows us to possess confidential records now and not disclose them would be what would allow us to receive this confidential information. And what this MOU, which the police department has indicated they no longer see as effective, what this MOU did was it streamlined something that the district attorney and the police department and us agreed to previously. It created a very fast bridge to get this information pursuant to this MOU. It just stated what the law we all knew to be already. Even if the MOU is no longer in existence, it doesn't, I don't think, destroy the ability under state law and local law for them to give us this information and for us to keep it confidential. Because we still have confidential records that no one has told us or instructed us we have to destroy. So all of the same statutory authority and that was reflected in our previous MOU could still be used to put that bridge back together and allow them to give these records to us.
And we've never had an issue with any of our confidential information, having any type of issue, breaches, or anything like that. They've sent it to us, it was confidential marked, and we kept it confidential.
That's right. Member Spencer, did you have something? And then Member Goddard, and then we're going to take the vote.
I did. Thank you. I think I have like two things very quickly. One, when we're talking about this evidence, again, I know I made the point earlier, so I don't want to overwater the garden, but this is stuff that we were already thinking about. We were already focusing on for so long. So it does not make sense to not have this information at all. And then what I also really kind of want to, and within that point, kind of hound on is that it does feel and seem like Metro Legal is just being used in like a certain way to be able to say that they just can't do it because they don't want to. That's what the feeling of it comes out to be, at least over on this end. I mean, folks feel a little differently, but it does feel that way. And also, I think on this issue, I forgot my other point. Can you go back?
Yeah.
I'm sorry. I forgot my other point.
Just in case you're having a senior moment, that's what it's called.
Don't do me like that. I just had my birthday a little while ago. Sorry. Thank you.
Happy belated birthday. Member Gardner.
Yeah, more law wants to hear probably. Slight disagreement with Legal Advisor Yoon. Before July 1, there was a state statute that required that we keep confidential information confidential. That went away on July 1. The problem legally is if we get confidential information from the police department now, no matter how many times they stamp it confidential and somebody sends us a public record request, we got to give it to them. There's nothing that says that is confidential in our hands. That's the legal analysis by Metro Legal. I think there's some merit to that.
Mm-hmm.
Okay, so point number two, or I guess this question, I'm personally a little just unsure of where we kind of go from this, because listening to a lot of the arguments that are being made, what my instinct, what my understanding, what my reasoning tells me is that we do need to go further and include some other party, be that the DA in some way, or it could be the grand jury. I think for me, and where I'm still trying to decide where I stand, is that it feels like we should kind of go farther, which is where I hear that there's disagreement that we have the basis to be able to do so. But I would like to investigate and going with the director's recommendation of the grand jury, but I would like to dig a little bit deeper, not just for myself, but a little bit for the folks at home. What would be some of I guess I guess I want to say the pros and cons a little bit of going a little bit farther with the grand jury. I think we've talked a little bit about that. Again, the basis of it, that it feels like that some of us don't feel like we have the basis to do it, but it does feel like we have to do something a little bit stronger. And I think given what we've already talked about within the ecosystem that we are a part of as an organization, that we have to think a little bit more outside of the box. We have to think a little bit more, and not to say that none of this is outside of the box, but to continue to be really crafty and creative and towards getting some kind of resolution out of this.
Okay, so I appreciate that, Member Spencer, and I do believe that we need to take the motion that Member Goddard put on the floor, but I want to interject this. We have an account from A.D. Kiley that the DA was most recently engaged, and we did not receive information that was requested from them. And so, to me, that is evidence that there could be some, some folks who are not cooperating with us, via the DA's office. So if we have that information, what would be a sufficient time if we forward this request to the district attorney? Do we give them, what was the time limit that they would typically give a response, or, that engagement time if we request the records or information?
I mean, I've never requested records from them in that way, so I'm not sure, and I'm not sure who we would, because I had contacted General Funk and both deputy district attorneys, Amy Hunter and Roger Moore. I put Sonny Heaton on that as the conviction integrity unit, and so I mean, honestly, I'm a little bit at a loss, because those are people I've known for years, and so I'm not sure who else you would ask except General Funk himself. And I did ask General Funk. He was on.
Did our MOU state a time frame that we had an expectation of receiving records being requested from the DA's office?
The MOU didn't have any requests from the DA's office because it allowed the DA to step back and basically say, MMPD, anything you've got that's Rule 16 privileged, I've authorized you to give it. So that wasn't there. I would suggest that we say we need it by our executive committee meeting. That's typically halfway between board meetings, and we would like to have this information by our next executive committee meeting, and point out this is one request, and point out it relates to one that we requested cameras and other stuff. It's well before July 1, and that's why we're asking for this now from him.
And if it is not received by our executive committee meeting, then what is the next step? That's the question, because if we don't receive it and they choose not to give it to us, then where does the case go? Where does it lie? So are we saying we will now forward it to the grand jury? I mean, where are we going?
I would suggest, it's late, but that's not the only reason. I would suggest we take it back up at the October meeting, and if we decide that we have the authority and it's proper to refer it to someone, that can happen before this board goes out of existence later that week.
Attorney Young?
This sounds, I know the recommendation proposed a little bit was to accept but modify the recommendation to speak to the district attorney.
No, it was to send it back to the staff with that, and then if you get any information, implication, if you get any additional information, revise it and bring it back to us next meeting.
That was going to be my suggestion, was to do a return, which is sort of a closure of this.
That was the motion to return.
Then we would have the opportunity to bring it back if we got to a point that we wanted board action. We may not. We may close it administratively. We may make, some other action, but I think that makes the most sense to do a vote to return this to MCO staff with that instructions, incorporating what the board has said. And then we have the option of bringing this back to the next board meeting, which would be October 23rd. October 16th is our reporting deadline to send this out a week in advance. So that gives us about 3 weeks. And if it's the executive committee meeting,
I think
which
that timing works.
chosen yet, we'll certainly try to meet that deadline as well. But our hard stop would be October 16th to present this back to the board, or we won't take further action on it.
October 16th to post it to be heard by the board at its next meeting, right?
And then so that should be right around the executive committee meeting. And if we request the information from the DA's office, right, then we should have it by whatever that Wednesday is before the board meeting.
October 18th is the day before the board meeting. I know at least I had suggested at the last executive committee meeting that we might have the executive meeting as early as October 11th.
Yeah,
due to
you
some other
did.
deadlines that we discussed.
Okay. So let's get that information or request to send it back to staff, request it from the DA's office by October 11th. Is that what we're saying?
Wednesday, is that the date you want to have the executive committee meeting?
I believe so.
We do need to have it up because we're
That's right.
out of time.
That's right.
So if we can do it October the 11th,
Uh-huh.
we have to post it 5 days in advance. So if there's anything that you want to put on the executive committee agenda, then we need to do that.
Okay.
Okay.
All right. So we have a motion to send this, return to staff for MNCO CC 2022-109. Return it to staff with the said instructions for requesting information from the district attorney and receiving that no later than October 11th.
And for clarification, I'm calling that Mr. Goddard's motion, and then is there a second?
Second. Anybody want a second?
Second.
All right.
All right, Member Spencer, all in favor?
Aye.
All right. Sounds like at least we're getting it somewhere.
Consensus.
You did.
All right, so, oh, sorry.
So we have a FUSIS update. Okay. Okay.
All right, so I want to just bring everybody into understand, we have to be out of here, cleared out before 30 minutes is up. All right, so we are way past our time. But it's been wonderful, so,
All right. Hello, everyone.
Hello.
Thank you. My name is Dylan DePriest, the data analyst for the MNCO, and today I will be doing a brief overview of FUSIS in Nashville. I know it's 7:30. We don't have much time left, so I will keep this as brief as possible since this is a first draft report. Also, I know it's a little bit hard in this room, but we have that projector set up back there with the slides, if you want to use that as a visual aid as well. So, to begin, on September 15th, 2022, MNPD entered a $175,000 sole source contract with FUSIS, which is under the $250,000 benchmark that would require council approval. From that contract, MNPD acquired 58 FUSIS devices from this contract, 8 for public use and 50 for private use. MNCO was made aware of FUSIS in August of 2023, when MNPD attempted to enter another $175,000 contract with FUSIS. However, instead of creating a second $175,000 contract, it instead amended the original contract to be $350,000. So it had to go in front of council, and that is how we were made aware of it. After discussion between MNCO and the sponsor of the resolution was withdrawn indefinitely by the sponsor. However, there is still a possibility that FUSIS legislation could return and be introduced again, especially since MNPD has a FUSIS run and hosted website that is still running. So, what is FUSIS? FUSIS is a technology that allows MNPD to integrate both public and private cameras across Nashville into one cloud-based server. As FUSIS advertises on its website, this creates a quote-unquote real-time intelligence ecosystem. So it can link police technology together and also cameras from both the public and private sector, including city-owned cameras, public school cameras, and LPRs on the public side, and security cameras, CCTVs, and Ring doorbell cameras, just to name some, on the private side. Currently, there are over 1,100 FUSIS Link cameras in Nashville. So, FUSIS has two main levels that they use: registration and integration. So registration is the first level, and that allows MNPD to know who has a camera and where these cameras are. And it adds those cameras to MNPD's GIS database. Integration is the next level up, and that provides the benefits of registration in addition to giving MNPD real-time camera access. So with real-time camera access, MNPD can access any camera for any reason at any time and watch it in real time. Owners of the camera can control what level of integration they want to give MNPD, so that can either be 24/7 access, or it can be access that is limited to certain time windows of the day or upon certain events. So this is an image of what FUSIS registration could look like for Nashville. This shows a cityscape with a bunch of different thought bubbles above different locations that indicate where there are cameras that are registered via FUSIS. Clicking on those bubbles would give you more information about who owns the camera. So now some Nashville context. Currently, there are 940 FUSIS registered cameras and 202 FUSIS integrated cameras. Pier City, Atlanta, first started using FUSIS in 2021, and now they have over 18,000 registered cameras and over 16,000 integrated cameras. So FUSIS has the capability to grow very quickly in a relatively short time frame. But FUSIS is more than just a data compilation tool. It also serves as a platform for police departments to integrate different forms of police surveillance technology into one platform. So this will connect all of MNPD's technology under, quote unquote, one pane of glass. So this is important for Nashville, since Nashville just had a pretty big turning point recently with the passage of a full LPR program. So this would create an estimated 117 LPRs for the full program, which would be a pretty sizable foundation for FUSIS to integrate into. Furthermore, FUSIS gives the capacity for police departments to create or download their own custom hot lists for LPRs. With the pilot program of LPRs, MNPD was only able to use the NCIC database, which is a national database that is heavily audited and regulated. We also found from our previous LPR report that LPRs were overwhelmingly placed in low-income and non-white communities, which could cause concern if MNPD is allowed or able to create customized hot lists, because then one could potentially create customized hot lists based on the certain areas or neighborhoods that LPRs are placed in. Furthermore, FUSIS also allows for ShotSpotter integration, which MNPD has tried multiple times to get since 2018. MNCO has also created a report on ShotSpotter in the past that highlights some of the issues and efficacy problems with ShotSpotter in general. However, there was a $800,000 line item for ShotSpotter in the fiscal year 2023 and 2024 capital improvement budget. So FUSIS could potentially be that extra kick that allows them to get ShotSpotter approved through council. Finally, for the Nashville context, Metro Nashville Public Schools and MNPD have an MOU together, or Memorandum of Understanding, which gives MNPD 24/7 by 365 access to cameras in public schools via FUSIS. The MOU outlines that these cameras are only supposed to be accessed in real time in the event of a quote-unquote health or safety emergency, which includes but is not limited to active shooters and bomb threats based on the MOU. Additionally, the MOU adds certain parameters to FUSIS use, including authorized users, so that only certain officers within MNPD will have access to MNPS's FUSIS devices. And additionally, those streams will only be able to be accessed via MNPD's Community Safety Center, which has not been built yet, but is funded via a $3 million grant to reduce crime rates across Nashville. Additionally, Nashville is getting a smart streetlight overhaul next year, and streetlights, smart streetlights specifically, in other cities have had the capacity to be FUSIS linked. Yes. That's a great question. So a smart streetlight is essentially a streetlight that has cameras built into it that are able to determine if there's motion or pedestrians or vehicles passing by and adjust lights accordingly. And so those cameras would be mostly in streetways and public ways where a lot of travel happens through. Absolutely. This, again, is another image of what integration could look like for FUSIS within Nashville. So you can see, again, a cityscape here. This time, instead of the little camera bubbles, it has different situations going on, of which someone presumably in a police department is sitting in front of a bunch of monitors, viewing those events from real time via those monitors, and then is able to dispatch officers in the top left corner to where they see things going on in these cameras. So now let's talk a little bit about FUSIS policy. We'll start with MNPD. MNPD does not currently have any FUSIS-specific policies, nor do they have any FUSIS-specific draft policies or SOPs, or standardized operating procedures. Currently, FUSIS is governed by MNPD Manual Sections 1210 and 1230. However, those are pretty broad sections, and they don't really have any FUSIS-specific sections. They mostly pertain to MNPD original files in terms of 1210, and mostly how MNPD personnel use personal technology devices in 1230. FUSIS also has terms and conditions that MNPD has to follow, but very clearly, in all capitals actually, on FUSIS's terms and conditions page, it includes a limitation that no party will be liable for any damages, direct or indirect, from following or not following the terms and conditions. So it's not legally binding. This is all kind of contrasted with Metro Code 13880, which was the Metro Code introduced for LPRs. Another, notable police surveillance technology that we have talked about in great detail. Part of that debate was definitely rooted in the fact that Metro had pretty robust policies in place, even for just the pilot program that governed, data retention and equitable placement, but nothing like that really exists for FUSIS. So now let's take a look on the national scale for what some FUSIS policies look like. Many other cities that are using FUSIS have policies in place, whether that is a full policy, a draft policy, or a CALIA-based policy. And for those of you who don't know, CALIA, I'm not pronouncing that correctly, I know, I'm famously horrible at pronouncing things, is pretty much like the gold standard for law enforcement policies. And MNPD is a CALIA certified program, but they do not have any CALIA-based policies for FUSIS use. Sorry, was that a hand, Maxine? Okay, sorry, my bad. So some notable peer cities include Lexington, Kentucky, which is another southern medium-sized city, which is notable for its community involvement in the FUSIS policy creation process, and also Minneapolis, Minnesota, a Midwestern medium-sized city, which is notable for its city code integration into FUSIS policy. So diving more into each of those cases specifically, the Lexington Police Department worked with some local advocacy groups in order to create their FUSIS policy. Of those were the ACLU of Kentucky, the NAACP chapter of Kentucky, and the Lexington Human Rights Commission. The policy includes crucial provisions, including things like data retention schedules, data ownership rules, routine audits, among many more provisions. In terms of Minneapolis, Minnesota, they have two big city codes that FUSIS policy is rooted in. Those are the Minnesota Data Practices Act and the Minnesota Public Safety Retention Schedule. So each of those respectively deals with establishing clear data ownership and usage laws and clear retention schedules for FUSIS data. And additionally, Minneapolis prohibits facial recognition software from being used with FUSIS and FUSIS integrated devices. So you can look up here. I know it's not very easy to see on the small screen, but the reports that you all should have access to includes this table as well. But this just views many different cities across the country that have FUSIS policies and what those policies cover based on some important policy provisions that we have outlined at the top. The main takeaway from this graph is that Nashville, while having some language around authorized users, lacks a lot of the important provisions that these other cities have. So there are some concerns regarding FUSIS. The first is a constitutional one, specifically around the First and Fourth Amendments, which protect the ability for citizens to have freedom of speech and freedom of movement. Constant surveillance from the police in both public and private spaces via FUSIS conduct what the U.S. Department of Justice calls a quote-unquote constant invisible searches with or without probable cause, as anytime someone walks past a FUSIS camera, whether or not they're aware of it in a, again, public or private space, they can be, viewed in real time by a police department. Additionally, it creates some data ambiguity. This is, again, another third-party corporation that will have access to the data of civilians in Nashville, specifically regarding law enforcement purposes. And it also, like I've mentioned before, there's a lot of uncertainty about what retention schedules would look like for this data. There's also some access uncertainty. MNPS MOU says that only limited employees will be able to view MNPS FUSIS devices and real-time footage, but we're unsure if that governs citywide usage. Additionally, this is concerning as FUSIS advertises itself as being easily accessible even from an officer's phone. And once again, facial recognition software, I think, is a very hot topic issue, especially regarding police surveillance. And right now, there is nothing that prohibits MNPD from using facial recognition software with FUSIS. which again would allow facial recognition software on any device that Fusus is integrated into. So, in conclusion, there's kind of three main takeaways that we want to leave you with regarding Fusus. The first of which, it's unclear what will happen with existing Fusus devices since there isn't a current Fusus policy, especially since many of those Fusus devices were purchased using private funds by the public from a Fusus-hosted MNPD website. The terms and conditions page of Fusus says that unless they have written exemptions or for termination from either party involved, then the terms and conditions will automatically renew. So that is probably the most insight we have into that first point. But there's a lot of uncertainty, which leads us also into our next point, which is that the citizens of Nashville know very little about Fusus, which is concerning for a program that increases surveillance, especially into the private sphere as well, and also one that asks private citizens to opt and buy into it. Some ideas for increasing the public's knowledge of Fusus could include public forums or releasing the locations of Fusus-linked cameras from MNPD's side. And then finally, expanding Fusus without proper policy is a pretty risky position to take, especially considering the scale of surveillance this would provide and the concerns we've outlined before. Yeah, thank you. Any questions?
Any questions? All right. I think what we have here is an ongoing conversation about Fusus as I'm really thinking about the new mayoral administration and kind of where we are going with the issue and the overall issue of public safety. And I think license plate readers is a part of that conversation. Fusus will be a part of that conversation. The Community Review Board will be a part of that conversation, especially with the in-depth research that we provide on a regular basis. So I would recommend that we revisit this report at our next board meeting, especially if we have some additional insight over the next 30 days regarding license plate readers and the Fusus technology. All right. Sounds good. Okay.
Perfect. Thank you. Yeah, so you all should have the draft, so feel free to send me any feedback you have, and I will be sure to implement it for a second version before the next board meeting. Thank you.
Thank you.
Motion to adjourn.
But, okay. Member Holloway, that's great, and I knew you were going to be the one to do that. But
Where's Jess Brown going? What is
any new business or announcements?
Now, I just want to say I want to thank you for this robust conversation tonight. This is what a community oversight review board should be discussing: in-depth issues in policing, public safety, technology, surveillance, all of that. And I think that we addressed all those things and made quasi-policy recommendations. So this is why this board is so important to this city, because these discussions aren't they're not being had publicly.
That's right.
And so I appreciate every one of you bringing your A game and your insight, your expertise, and your concerns about our community. So I appreciate you. Thank you so much.
Thank you, Director Fisher. Now, Member Holloway.
Motion to adjourn.
All right, can I get a second?
Second.
All right, all in favor, let's go.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.